ಇದು ಮೈ ಖಾನ
My lords, WP number 1 of 2018, my lords.
Yes.
My lords, suit is of the year 2010. The respondent is 70 years old, my lord, sir. It may be heard at the earliest.
Yes.
List number two, serial number 3. I may permitted to file retirement memo of retirement. And I
Which case?
retirement memo in list 2, serial number 3. I intimated to the petitioner counsel.
What is this? Oh, this is the one which
Yes,
which has come up.
yes, lordship.
Hmm.
And since she's not interested to continue with this,
Mm.
and she told she'll bring other advocate today. So we our name may be-
Whatever it is, when the matter has come, on that day, there's no objection, business will not work out. Tell the client, let her make alternative arrangements. By the time the matter is called in the afternoon, she should be here with an advocate. Don't file it now. Don't file it now.
Okay, I may permitted to file with counter, lordship.
File it in the counter and tell your client that the matter will be heard at any cost.
Yes, lordship.
My
Much
lord,
obliged.
kindly, serial number 17 of list 1, I appear for the respondent.
Serial number?
17 of list 1.
My lords, this is a rent recovery matter.
They'll start, she'll call. Call.
Number 1 for orders matter, serial number 1.
The applicant, Lord, I'm
Yes,
seeking,
Shalbatti.
Lord, I had earlier, Lord, was unable to be represented for the cross-examination of PW1.
Hmm.
But I have, now, Lord, I have filed an application seeking, Lord, permission, Lord,
What
firstly,
is
Lord, to,
that, what is that application?
but the application is first one, 371 of 24.
Hmm.
Seeking, Lord, recall of the order dated, whereby, Lord, the stage was closed. Stage of cross-examination of PW1 was closed. The earlier advocate, Lord, who represented the applicant, Lord, apparently returned the file or some such communication. Lord, the applicant could not be represented for the cross-examination of the witness. So, Lord, I am seeking recall of that and permission to conduct cross-examination.
When was the order passed?
23, my lord. 2023 of closure of stage. My lord, I have filed a application for seeking condonation of delay also.
Why, what is the delay?
The client was not aware, my lord. The applicant before my lords in this application was unaware because according to him, his lawyer did not communicate and he was under
And
the,
what did you do when the lawyer has not communicated?
Lord, no action as such is required unless my lords were to find fault. But that's why, my lord, I'm seeking.
No, just like that, you
Yes.
can't file an application and throw the blame and burden on the advocate. The
No,
client can't
Lord,
do
I am
it.
not saying that. The applicant saying he did not coordinate with the lawyer also. That is the reason why, my lord, this application is filed. Your lordship, my lord, condones it.
Yes,
Hota. Sorry.
copy is also not served.
Sorry. I mean,
It's
my,
filed on 7/8/2024.
yes, my lord. I'm sorry, my lord. Just time.
Lapses at every stage.
Yes.
This is matter. It is submitted that by the advocate appearing the official liquidator that the application that is 371 of 24 is not served. And what is this 433 of 24?
That is for seeking condonation of delay.
433 of 24. Then comes for the applicant submits that he'll serve the papers today. List this matter on 5th of March.
I'm not any sooner date because 25/2 is the
List it
date.
on 19th of February.
Great.
Yes.
Raghavan for official liquidator, Vijay Kumar.
File who do it? File. File.
Yes,
Address to fund.
have you received it, Mister? Have you received it? So what is to be done now? He has complied with it. He has complied with the order passed by the court. Learned counsel, this court on 31/20/25 directed the matter to be listed today, and the address and contact details shall be placed before this court by
Original.
serving a copy on the official liquidators, or else warrants will be issued. When counsel submits that, he has filed the address proof and the details. And also served a copy on the OL. OL submits that, he has received the copy today, and he will he will verify the same. This is on 11th of March. Yes, next.
Sale number 3,
Obliged. Hey, number one copy.
Yes.
ಕೊಡ್ರಿ. Number one
Modern-
copy ಕೊಡಿ ಆಮೇಲೆ.
for petitioner, Mahadevan, for official liquidator.
I'm for the.
Last time also it did same thing.
Short passover. Ask him to come.
Please.
Yes, for.
Sale number 4.
Then where is the wakalat file? Where is the wakalat? Wakalat.
Wakalat is coming. We are filing today.
He has to file wakalat, is it not? You are representing as a party in person.
Yes.
How can an advocate represent you now?
He is filing, he is ready. Wakalat is ready, he is coming.
think he is not, he will be filing now.
Now it's.
He'll file now and he'll argue now. Yes,
Sale number 4,
My lords, this is an application for recovery of arrears of rent.
Okay, for the respondent,
Surrender,
I filed an application for leading secondary evidence. The matter is pending before the project coordinator. We've led evidence in part. The 2 invoices that the OL had sent, which we do not have originals of, and therefore we seek to lead secondary evidence in respect of those invoices, my lords. CH-10 of 2025.
no, what is the application now?
So an application for, official liquidator's application is for recovery of amounts that they claim
Let's
to be
see,
due.
what is that, see, application number 10, na?
Application number 10, my lords, is for leading secondary evidence.
My lords, I have not been served a copy of 10 of
My lords,
2025.
proof of service is enclosed with the application at the end. It's
My instructions are the office does not have a copy. May I refer to an order of your lordships dated 25th April 2024.
I've also now furnished. an
There
additional
they've said
copy.
they do not dispute the tenancy. What is in dispute is the amount. And on that date, they had undertaken to enter into a
So
reconciliation
you'll have the
exercise.
copy of this 1 of 10.
I have
I mean,
some.
10 of
again, my lords.
2025. Look at it. Passover,
No, my lords, if I may just refer to a previous order of the coordinate bench. There doesn't seem to be any major disputes on the tenancy. It's only the amounts that are in dispute.
what is, according to them, what are the admitted amounts?
My lords, they'll have to point out. Can I just read the order that's dated 24th April 2024?
Yes,
A memo dated 23rd April
24th April,
2024.
24th or 25th?
25th, my
24th,
lords,
my
I'm sorry, 25th of April.
Yes,
A memo dated 23/4/2024 has been filed by the council for respondents number 1 to 3. The learned counsel submits that the submission made on 14/2/2024 is not in as much as dispute as regards tenancy, but as regards the amounts due from the tenancy, and as such, if an opportunity is granted to
what is this
reconcile the
order
accounts.
dated 14/2/2024?
My lords, it was previously recorded that there's no dispute again on the tenancy. They're not disputing the tenancy
No.
per se.
The court says the order dated 14/2/2024 is kept in abeyance. Where is that 14/2/2024 order?
My lords, that's referring the matter to CPC
Oh, that is.
for
kept-
recording of evidence.
Hmm.
Thereafter, the court records that in view of the matter, the order
Application
dated,
is filed to reopen.
Is. my lords may just have the
Inquiry
last
is to be
portion of
held.
the order.
Then the latest order is that the tenancy is not in dispute.
In dispute,
And
they have
what
to,
is this application?
now they want to
10.
tender secondary evidence. All
For
I'm
what?
saying is they want to mark some invoices. All I'm saying is if there's no dispute as regards the tenancy, there may not be any need for them to tender evidence at this stage. A reconciliation is all they're
See,
seeking.
let's see, what is that application filed by them?
My lords, as rightly pointed out my learned friend, there is no dispute on tenancy. There is a dispute on the amounts claimed as arrears.
So now, what about the admitted
But
amounts?
paid all the admitted amounts, my lords.
Even right now, I mean, even till now, all admitted amounts are cleared.
Paid the admitted amounts, now this
Is
is.
is it correct?
No, my lords, we have, as per our records, the outstanding as per the agreement comes up to 20 odd lakhs.
What is the admitted rent according to you?
My lords, admitted amounts have been paid over time.
No, where did you say,
As-
what is the amount admitted, when did you pay, how did you pay? Where did you say so?
My lords, at the time, when the application was filed, after that, some payments were made, and in the rejoinder, the applicant had admitted and
You have
reduced
to
the
be
claims also.
clear, you have to be, in your submissions, you say that there is a dispute with regard to the quantum of amount.
Please, my lords.
So according to you, what is the admitted amount? How much it is? When did you pay?
Please, my lords, I will just take my lords to that.
I can give them my current statement up to date, my lords. This is a statement that we've prepared to show what is the due up to date.
Then we'll pass over this matter. Take that according to them, what is outstanding
Please, my lords.
and get instructions that what is that paid till now.
I will, my lords, my request will be taken at 2:30.
Yes.
Case number 5. Mahadevan, state that cheaper.
Hearing for respondent, my lords.
Respondent.
We have filed our wakalat, my lords. Kindly grant 2 weeks time to file our reply, ma'am.
My lord, I have filed an application, my lord, according to me, my lord, personally, we have filed it in time. Because the date of winding up order, the date it will be taken inclusive, my lord, then it is in time. But registry has made a note that it is 1 day delay is there.
They've come.
Yes,
They've
yes.
come, they're on record, then council submits that. When already wakalat is filed,
Yes, my lords.
they'll file their objections to the application and seeks time. This is matter on 11th of March.
Case number 6. Tempest TS for.
Your lordship, this is arrears of maintenance, your lordship. Your lordship, the burden bench has passed on page number 34, your lordship. Earlier, page number 34, your lordship.
My lord, I appear for the applicant in 164 of 2021.
Oh, the connection matter.
Yes, please, my lord.
145, appearing in 145, your lordship.
Hmm.
Your lordship, with
Now
respect.
let's understand what is this one.
Your lordship, if 140, your lordship, in this case, page number 34, your lordship.
What is the order in 145? You are referring to a coordinate benches order.
In this case, that we have sought for the arrears of maintenance charges, your lordship. Total 9 flats were maintained by Kirloskar. Kirloskar came into liquidation, your lordship. So since the flats were vacant, the maintenance charges were not paid. So we filed earlier this 29 of 2009 seeking arrears of maintenance from the official liquidator, your lordship. In this petition, that page number 29, they paid the maintenance charges with respect to 8 flats, your lordship.
1 minute, 20,
Page number 34, your lordship.
34.
May I beg your lordship, page number 36.
Hmm.
In the tabular column, I have mentioned the flat numbers, your lordship. The present petition is with respect to BB5, second column, second number, your lordship. 12,95,000 or 12,95,000. Your lordship got it? Now I beg your lordship to page number.
You are referring to para number?
Page number 36 ali, there is a tabular column, your lordship,
Yes.
that we now, with respect to other flats, the maintenance charges has been cleared by OL, your lordship. With respect to BB5, that second item, your lordship, that in tabular column,
BB5.
BB5, that is pending, your lordship. May I beg your lordship to page number 38. 38, para number 9, your lordship.
Hmm.
It is made clear that the aspect of maintenance charges relating to B5 is kept open and the present order will not come in a way of the owner of flat number 5 putting forth his claim for maintenance charges before the OL, and the contention of the owner of flat number B5 is kept open to be adjudicated in separate proceedings. In this context, Your Lordship, I have filed. Simultaneously, OL has filed CA number 117. That is also pending before, that is also posted to Your Lordship. In that, OL has 117, Your Lordship. I have produced that copy adjacent to this, annex that copy also, Your Lordship. So I beg Your Lordship to page number 27, 28, Your Lordship. In this only the prayer is there, Your Lordship, with respect to the 28 page number, Your Lordship. That is the prayer in 117, Your Lordship. A direction may be issued to respondent 1 to recover the maintenance FMC with respect to flat number 5 from the respondent 2, and inter-alia respondent directed to pay all the society charges.
Who is respondent number 2?
Please, my lord. I am
Who is
respondent number
respondent
2.
number 2?
My lord, I have one submission. The counsel on record has suffered an injury and has been advised 3 weeks bed rest. I request this matter be taken up in the 3rd week of February. And as far as my application number 164 of 2021 is concerned, the registry has raised certain objections, my lord. I'll cure the defects before the next date of hearing.
In respect to CA number 145 of 2024, when counsel representing the respondent submits that the respondent is unwell and requests a time. In 6.2, it is submitted that they'll comply with the office objections. This is matter on 4th of March.
Much grateful.
Till number 7.
So in this case, I appear for applicant in CA number 86, madam. 86 of 2022. Madam, that is an application for impleading me as a party in the proceedings that is in CA 85 of 2022 filed by the other applicant. So my application came to be allowed. So the in CA cost title has to be amended by the applicant in CA 85, madam.
We don't have the copy of the application filed by them.
But I am told it is already ordered. That's what he's saying.
My lord, CA
86 is already allowed.
85 of 2022, my lord, filed by other side, copy not served. My lord, my records don't have a copy.
It is filed by KIDB.
No, it is filed by
Your
Suri
implead
Auto, madam.
No, your implead application is CA number,
86.
that is allowed.
That is allowed, permitting me to be impleaded in CA 85.
Yes.
So they have to implead me in the, they have to make me as a party in the CA 85 by
Yes.
amending the cost title.
You don't have the copy of CA 85.
CA 85, I don't have.
It's
copy.
filed by whom?
CA 85 is filed by KIDB.
Who
It's
represents?
not filed by
the-
KDB, it is Suri Automobiles.
Madam, BV Chandrasekhar appears for KIDB.
OA and Co, madam.
The CA number 86 of 2022 is allowed on 23/6/2022 by impleading the proposed party in CA number 85 of 2022. The amended cost title shall be filed within a period of 2 weeks.
My lords,
One
there
request.
is an application, report, my lords, OLR 334 of 2024, whereby, my lord, there is a matter going on in Supreme Court, Honorable Supreme Court. We had hired a lawyer. Now, my lords, this application is pending for long. We have to pay the fees, saying I can't appear without the fees. So for that, we have filed it, my
My lord,
lords.
your lordship may kindly take for one
OLR?
107/23, my lord.
Good night.
There are two OLR, my lord. One is for advocate and record, my lord, payment. Another is 34 is for regular advocate.
Both applications,
OLR.
107 and 34.
Copy of those OLRs has not served on us, members.
That is nothing to do with him, my lord. I have to pay my advocate fee to him. If he is objecting that, he may be permitted to pay.
OLR 34 is?
107/23, my lord.
No, there are two. OLR 34 is?
34 is.
To permit
Lord-
official liquidator to engage the service of CPS Singh,
Yes, my lord.
Delhi to appear before the Honorable Supreme Court of India. Then 107 is?
AOR appointment, my lord.
Advocate on record.
To pay the fee of AOR, my lord.
No, what are the rules for this?
My lord, there are no rules. We just usually what happens, there are lots of cases going on, my lords. So we'll hire a lawyer if there is an urgency and then put for ratification. If there is no urgency, we'll first put an application, take permission from my lords and then hire. These are the two things. There is no set rules for this, my lords.
No, it is like, what is the fee structures?
No,
and all?
no fee structure is defined.
Whatever
my-
you engage a lawyer, you will charge 1 crore 50
No,
lakhs.
my lords,
or
we
50 lakhs.
usually act as a
No,
very
I'm just
poor
asking
office, my
you.
lord.
I'm
No,
just
that
asking,
doesn't.
How it is?
My lord, there is no,
Something,
there should be something, my lord. There is no bar, but this office maintains my lord, the
not
least fee
different
lawyers we have.
aspect. Whether it is all, it shouldn't be like basing on the official liquidator, because you're following certain rules. There should be some rules for this.
But my
You know,
lord,
like, for example, you have to engage only the one, this I saw in the first application.
yes, my lord.
That for availing legal services also is a central government standing counsel.
Yes, my lord.
You're engageable.
Yes, my lord.
That's fine. So even for the others also who are on the central government, if you take their services, there is a
Schedule fee.
My lords, may I submit some?
Schedule fee.
schedule fees will be there.
My lords, we have asked for permission to pay the schedule fee only.
No, that is in one application.
But my lords, what happens usually, sorry to make a submission like that, my lords. My lords, in some cases, the gravity of matter is different. So my lords, everywhere we can't go to CGSCs, my lords. But it usually doesn't happen barring a few cases. In case that happens, we'll first take permission from the Honorable High Court and then engage the lawyer.
The one-time total fee, 1,25,000.
My lord, that would be based on appearance because the central government.
That's appearance, not a one-time fees.
No,
For appearance, it must be.
no, my lord,
No,
payment
no.
to AOIR is one-time payment.
Huh?
Payment
No,
to-
no, OLR 34.
Yeah.
My lords, OLR 34 is basically my,
I understand. OLR
Yes.
34 is a central
Yes,
government
my lord.
advocate,
yes.
basing on appearance fees it will
All
be.
right,
Yes.
all right.
And the second one, this advocate on record, that is 1,25,000 is one-time fees.
One-time payment.
One time for the whole case.
Uh,
My lord, I mean,
OLR.
this also sounds very high to a new matter has come. I am engaging an AOR for 5,000 per hearing, but this is an old case, my lords. Not much I can do about it.
That's why because that's what the official liquidator has to do. So that the much amounts are not spent and at the same time you get good legal advice.
My lords, I can't comment on my predecessor's work. my lord.
OLR number 34 of 2024 is 5. Taking leave of the court to engage an advocate for appearance in SLP number 17404 of 2023. To engage the services of Advocate Sri P.S. Singh, then CG-SC Delhi to appear before the Honorable Supreme Court of India in SLP number 17404 of 2023 to represent the official liquidator. Further, to permit the official liquidator to incur expenses for availing the legal services of the council as per the rate fixed for the central government standing council by the Ministry of Law and Justice. Accordingly, the OLR number 34 of 2024 is allowed as paid for. OLR number 34 and the other is 107.
107, ma'am.
This is filed with the official liquidator. This report is filed with the official liquidator, seeking permission to engage an advocate to appear in SLP's civil number 17404 of 2022-23 before the Honorable Supreme Court of India. They want to, the official liquidator wants to engage the services of one Sri Gundam Venkateshwara Rao, advocate on record, for appearing on behalf of the official liquidator. And they also seek the permission of the court to pay one-time total fee of rupees 1,25,000. No, this is you have already engaged, or you're going to
Hello?
engage?
My lord, so what had happened, usually in the cases will be served with the notice and we'll make them make an appearance. Now, my lord, this has been pending for 1 year and another is pending AOR 1 for 2
Already
years.
engaged.
Already
ma'am.
engaged.
Officially, in the other matter also, as the matter is in the other report, as it is already as this report is pending, and in view of the pressing necessities, they've already engaged the services. In this also, they've already engaged the services of Sri Gundam Venkateshwara Rao, and the paying a one-time total fee of rupees 1,25,000 plus GST. If any, for appearance, drafting, filing a reply. Again, you said the appearance, just now you're saying that what is one time.
My lords, because
My lord, normally, my lord, advocate, without advocate and record, my lord, this advocate.
That is true, but in that case, why should you write if any per appearance, that he will be the advocate on record?
my lords, may I submit something? My lords, OLR 107 may please be posted for a next date. I'll come with a clarity. OLR 334 may be allowed because he's pressing for his fee. That's CGSC, my lord.
Yes, that no orders on this. And let there be some procedure for
All right,
this.
all right, my lords.
Every time it can't be on the whims of the official liquidator. This is matter on 19th of March.
Serial number 8.
I appear for the official liquidator, my lord.
Yes.
This is the matter that was taken up last week, my lord, with respect to deferment of lease in UB City, my lord. We had paid refunded EMD of R2, my lord, as per your lordship's order last week, my lord. Your lordship had directed us to file a memo with details of schedule of sale of movable assets, my lord. My colleague is tendering that across the bar, my lord.
Sir, it is serial number 8, sir.
Serial number 8, please. My apologies, my lord. I am in 9.
Serial number 8, Aditya Sondi for petitioner, R. Virendra Sharma for respondent.
No representation on behalf of both the parties. This is matter on 15th of April.
Serial number 9,
My lord, appearing for the official liquidator. Apologies, my lord. In
Before my
this,
learned friend comments, I may just make one submission. I thought my learned friend may be making submissions in CA 385. Before
Yes.
that, Maharaj, there is one CA 273 listed. That may be deferred for some time, Maharaj, because there's a related issue pending before the Honorable Supreme Court, where a learned single judge of this Honorable Court interpreted a particular order in a particular manner, which the banks challenge. Division bench dismissed the appeal. Supreme Court is seized with the matter, Maharaj, where a stay has been granted. So this may be deferred because an outcome of that will have a direct bearing on this. That's insofar as 273. That's where I'm appearing. 385, my learned friend may.
Yes.
Grateful.
already noted, my lord, the previous hearing with respect to 273. It is pending, my lord. 385, my lord. My colleague will tender a memo with the details of proposed schedule for the sale of mobile items, my lord. The first milestone, my lord, is to receive the valuation, my lord. The promise of the IBBI valuer is that they will submit the report by 12th of February, my lord. Thereafter, if I may invite your attention to paragraph 3, my lord, I have placed a table based on assuming that I get the valuation report by the IBBI valuer on 12th. These are the things that I will start doing, my lord. The date at serial number 2, my lord, I have taken as X, my lord. That depends on listing and allowing of the application, my lord. Post that within 30 days, I am able to complete the movables sale, my lord. In this, my lord, if I recollect on the last hearing date, respondent number 5 had made an offer to purchase whatever is there in the building, my lord, that they can bid in this auction itself, my lord. If they are successful bidders to that, we have no objections to hand it over along.
Then what about this valuation report? That's a crucial.
Please,
One
my
of
lord. We hope that we will secure it by 12th, my lord. Once that is done, the base price has to be set by this court, my lord, looking at the valuation report. That
How
is,
likely it is to be by 12th?
my lord, it should be at least by 15th, 2 or 3 days here and there, not more than that, my
So
lord.
you will be placing this report on 17 too. So
My lord,
we'll list this matter on
5 days, I am saying from the date of receipt, my
so
lord.
that's why we'll list this matter on 20th. So that even if another 2-3 days,
My lords,
if you can place the report, then
My lords,
further things.
my lords.
Once the court passes an order,
Then my
grants
lord,
you
30
permission,
days counter.
then you
stands.
can proceed with.
Yes.
My lord, in 385, I appear for respondent 1, my lord.
In 80?
385, CA 385, which is what my learned friend is submitting on. I filed a reply on behalf of R1. Their concern was that because movables can't be moved out and it's taking some time, that they want to return the EMD amounts. I'm making a submission. I've filed a reply to that effect that they can keep it. I'm not even going to claim interest on it. As and when, my lord, the movables are sold and then they are able to hand over vacant possession, I'll take it, my lord. I have succeeded in the auction in respect of 4 floors, my lord. Out
So
of
what do you
these,
want now?
my lords, all I want is that let the EMD amount be kept with them. As and when the sale is complete, my lord, and they are able to give me vacant possession, I'll take it. So there's no need for the return.
Yeah, I mean,
And the OL also will not be
No,
prejudiced.
that's provided you want to,
My lord, I'm sorry.
provided you want the refund of money.
No, I don't want the refund, is what I'm
This
saying.
will not pass any order.
Yes, my lord, no order may be
Because
necessary.
on the other, on the last occasion, somebody else wanted, then an order was passed.
Yes, my lord, I don't want the refund. I've placed that in writing also. I'll
So
wait for,
here, let's see that application.
please, my lord.
Give that 385.
385, my lord.
Your
I'm for R1, my lord.
R1.
That is Chaya Real Estate.
And in respect of R5, you have written the
R2, my lord, we have returned.
R2.
R2, it is, the application is allowed in terms of alternate prayer B and it is complied, my lord. The rest will be kept pending subject to the valuation report and the outcome, my lord.
Yes. Please come. On 31/20/25, the court passed an order observing that the official liquidator submitted that by the next date of hearing, they will come up with a timeline when they'll be able to complete the
Sale of movables, my
sale
lord.
of movables. Today, a memo is filed before this court stating that they will receive the valuation report that it is as per the valuer. As per the email received from the valuer on 31/20/25, that he'll submit the report on 12/2/2025. Once the report is submitted, they can place a report before this court by 17/2/2025. And for 7 days, they require for publication of the sale notice and inspection of movables, another 14 days. And the pre-bid training to be intending by buyers for online bidding, it takes another 21 days.
May I make one clarification, my lord?
Yes.
They are not in addition to each other, my lord. They are starting from the date
So
the
you
court.
right from 17/2/2025, you
Please, my
require
lord.
30 days.
My lord, subject
If
to.
it is permission is granted on 17 by
Please.
the court, you
Please.
require 30 days from there on.
Please, that is correct.
It is stated that once the valuation report is placed before the court and the permission is granted by this court to proceed with the sale, from there, they'll require at least 30 days. 30 days, considering the memo placed before this court. Lists this matter on 20th February. And by the time the official liquidator will place before the court the valuation report. Yes.
Serial number
Wait.
10.
Grateful, my lord. I appear for the official liquidator, my lord. This, my lord, is with respect to a voluntary winding up petition, my lord.
I appear for the voluntary liquidator in this matter, my lord. We
My
have
lord.
filed a response to the OLR, and on the last date of hearing, the OL's counsel, my lord, had taken time to file a rejoinder. Whereas we've not been served with any rejoinder.
Yes, sir. I'm addressing that point, sir. I'm seeking 2 weeks time to file that rejoinder, my lord. Your lordship, am I audible, your lordship? I'm seeking 2 weeks time to file that rejoinder, my lord. I'll have it placed on record.
I'm just looking at what has happened on the last occasion.
Please, my lord. There are 2 OLRs which are connected, my lord. OLR.
Official liquidator seeks 2 weeks time filing the rejoinder. This is matter on 12th of March.
Serial number
Great. Great.
11 for orders, official liquidator.
My lords, this is an application for recovery of arrears of rent. On the last date, I'd furnished our statement of accounts and what we deem is due as per our books.
Request of learned counsel for the respondent number 1, lists this matter finally on 6/2.
My lords, I have inquired, my lords, we've already filed one memo, my lords, on 12th of September 2022, whereby, my lords, again, at the request of the office of the official liquidator, the entire dues, my lords, of 10,95,000 were cleared. Subsequently, we have been making payments, my lords. Now, the subject matter of this particular application, 95,000, my
You have
lords.
paid.
Yeah, we paid, my lords. As on,
According to their memo, how much you need to pay?
my lords, their memo, my lords,
2,59,043 rupees.
After deducting this amount?
Yes, yes, after deducting that amount, it's 2,59,043 rupees.
What is this difference in calculation between any?
My lord, that is what he was supposed to furnish to us on the last occasion. I'd in fact given them a copy of this sheet, in fact, 2 days ago. He said he will reconcile as per my present statement and explain to the court what would be the discrepancy, if any.
my lords, I have inquired. The only pending from our end is for the months of December 2024 and January 2025, my lords. The receipt along with the detail, the ledger, my lords, would.
To how much?
No, that's about monthly, it's about 20 odd.
20,000 rupees.
20,000 rupees.
So, but still,
Approximately.
it is not matching. You say that it is 2 lakhs. He
It
says
is not
is
matching, my lords.
50,000.
Correct.
Then where is the difference?
My lords, the official liquidator hasn't specified what I can make of from their application, my lords, is they have levied some.
Application, he may refer to the latest reconciliation statement. It was listed
That-
today only for his response to the same. The application, those arrears were due as on the date of filing the application. I'm giving him a statement up to present date.
No, you look at the statement. That's what the matter is adjourned to today.
No,
Look
that-
at the statement. According to you, like what is, which amounts you are admitting, which amounts you are not admitting, that you have to tell the court.
I will also file it, my lords. I will require a few more days because I have already.
That's what the order is finally.
Please, my lords, I do, my lords. I apologize for the delay, but I have sought the clarification. This is what was conveyed, and my lords, I have asked for the
It
relevant
has come
documents.
upon- It has come upon.
Please, my lords, it has, my lords. It has, my lords.
An order is passed against
Because-
31/2020.
Subsequent to it, I've been making payments, my lords. From the memo, what I can surmise is that they have
Then
sought
first
for
of all,
escalated
No,
amounts.
within a week, pay that 40,000.
We'll do that, my lords. That we have, I'll undertake to pay the 40,000, my lords. Whatever is due for December 2024 and January 2025, that I'll pay, my lords. I've been paying since 2023. There's no dispute regarding that.
Yes, Mr.
So, my lords, we have made the calculation as per waiver, without waiver. This amount is due, my lords, because every year there is some shortfall. Now, my lords, if they have some specific thing they don't want to pay or they are not admitting to it, then they should have clarified it. That I'm waiting for, my lords. This 40,000,
No, he's seeking time,
my lords,
a week's time or whatever it is to clarify that.
my lords.
What this court is saying is, will direct him to pay the first at 40,000 and then within a week, place that also.
My lord.
Serve it on.
My
Please.
Learn it, according, as per the calculation of the official liquidator, the respondent tenant has to pay an amount of rupees 2 lakh,
My lords, the 2,59,000.
2,59,000.
43.
40?
43,
43, 2 lakh for, 2,39,000.
59, my lords.
59,043. And on the last occasion, when the matter came up, on the last two occasions, the land counsel appearing for the respondent.
That's one submission here. The prayer sought for in the memo is payment of 1,68,271 and interest at 12%, my lords. So if that
My lords, again, he's referring to a memo of an older date. I have given him the statement of reconciliation on the last two occasions.
Without interest.
Without interest, this is only principal.
And on the last two occasions, the matter is adjourned at the request of land counsel for the respondent to get specific instructions, whether they are admitting the said amount or if there is anything wrong with the calculation. Even till today, he has not filed any memo or reply to the said calculation. Then it is submitted by the counsel for the respondent that as per his instructions right now, for the month of December 2024 and 2025, they are due of an amount of rupees 40,000. And with regard to the other amounts, they'll come up with a memo, public reply. And he requests and he seeks some time for that. Considering the same, this court is passing the following order. 1. Within a week from today, the respondent shall pay the 40,000 amount, which is due for the month of December and January. December 24 and January 25. Next, the number 2, the respondent shall file their reply, a memo to the calculation memo filed by the official liquidator within 2 weeks from today. This is matter on 4th of March.
Till number 12.
My lords, this is also a similar matter.
Number 1.
They had to get back on.
No, on the last occasion, I had filed a memo of calculation, if your lordship.
My lords, yes, I'm sorry. It's for our response to
Indeed.
this. We have come up with another statement of.
Have you given him? Have you served him a copy?
I've just given a copy to him, my lords.
But in most of the cases, not that particular one, the difference is because they are calculating their COVID waiver as per their own volition. This Honorable High Court has passed a specific order what COVID waiver for tenants would be. We are calculating as per that Honorable High Court order. That's where the major difference of calculation is coming. In this case also, my lord, that one is the difference.
May I take instructions on this? On the last occasion, I had filed a memo of calculation, but I need to verify.
Filed by the land counsel for the respondent on the last occasion. In response to that, the official liquidator has given the calculation and served a copy on the counsel for the respondent. Respondent counsel seeks time. Let's this matter on 20th of February.
Grateful.
Till number 13. Liquidator, Gangabai.
last occasion, Lords, the OL had given a calculation memo. Lords, I am giving a calculation for reconciliation, Lords. I'm also filing it. Lords,
My lords, 1 week's time may be granted. On
I
will-
memo.
The land counsel appearing for the respondent has filed the memo of
Yes, ma'am.
calculation and served a copy of the same on the OL. The official liquidator seeks time. This is matter on 25th of February.
much obliged. Sir.
Till number 14. Official liquidator, B.N. Prakash.
My lords, this is also for recovery of arrears of rent. As on date, the arrears are about approximately 10 lakhs without any interest.
No representation for respondent number 1. Then we'll pass an order.
Very well, very well.
Where is that application and what is that?
My lords may refer to CA 234 of 2020. If I may just pass on a statement of views as on date, my lords, just for ease of reference.
Any interim order in this? This is application is filed
Yes,
by
my
you.
lords.
And in
Yes.
some of the cases where they are not paying the rents and all, I think that essential, that the supplies and all you have disconnected or something.
No, my lords.
Mm.
There were, my lords, we took the 10 tenants who had the highest paying dues because we wanted to be uniform in our approach. And who were not regular in paying rent even after the case was filed. So wherever the current dues were also pending, we took the matter. So my lord, most of the people are there who are generally paying their current rent, but my lord.
Only the dues are there.
Dues are there. So in between, if they miss a payment or they have not paid earlier, but in general, they are regular. That's why those notices were not sent to them. Only to 10 people they were sent who are not paying even now. So this is the matter. He's still continuing with the place, my lords. I don't know why they are not.
He's continuing.
Yes, he's still there, my lord. He's attending. And I can see the payments are being made on regular basis, but these dues have not been clear. And my lord, we have given two calculations. If my lord may have a look at the sheet. With waiver and without waiver, that waiver has been calculated as per.
Where is the summary and?
My lords may have the application. This point was included or? Okay, summary.
First page of the calculation, my lord has it. My lord. In that, my lord, we have given. Yes, my lord. My lords, the second column, 6,16,000 with waiver. If I apply it as per the Honorable High Court order. My lord, the first page, there is a summary, my lord.
Summary is there.
Yes, my lord. So if my lords may see my, the second column, that's with waiver. Though there is no specific.
With waiver.
But there is no specific court order to that effect, my lords.
My lords, if I may just add to the OL submission, the coordinate bench of this honorable court granted waiver to those tenants who genuinely had some difficulties in making payments during the COVID period, not for chronic defaulters. So that principle of granting them that concession for COVID period, it was of course applied on a fact-to-fact basis.
What's the kind of business?
My lords, this is a kiosk. My lords, it's a jewelry brand called Swarovski. It's a smaller space. It's more like a kiosk over there, but they're quite operational.
So why not the COVID, whatever the waiver that is given to the others, they are not entitled?
My lord, some people have themselves taken waivers, which we are fighting now. So my lords, it may be a case where they have considered the waiver in their own books without even court permission or intimating the OL.
No, what the court is saying is, when the court has granted in many of the cases.
Not many, my lords. Few cases where they genuinely showed that their business were affected because my lord, on the other side of the spectrum, my lords, I have poor creditors.
Now this jewelry business, how it will run in COVID? Why people will come and buy the jewelry?
My lords, this may be a case, my lords. I have thousands of.
No, we are looking at this. We are looking at an independent case. So I think looking at the kind of business they are doing, I think it can be not for everything. How can they come up with, we don't have to even look at the other details. So that's why what is to be done now?
My lords may order, my lords. I'll serve a copy and send someone physically. They are present there.
In spite of an order? In spite of there is no representation on behalf of the respondent on 16/1/2021, 11/2/2021.
My lords, in fact, they're represented by counsel.
On 27/5/2021, they have represented. On 19/4, who is respondent?
My lords, 2 is Prestige
19/4,
Estates.
2023, represented before the court. Then again on 31/2025, there was no representation, and hence the matter was directed to be listed today. Even today, there is no representation on behalf of the respondent. Which advocate is appearing?
Yeah.
HP Rudresh.
Please.
Land counsel HP Rudresh has filed wakalat for R1. When the application is filed way back in the year. Huh? No, that is not right. It appears that the respondent, best reasons known to him, do not want to pursue the matter. This court had perused the application filed by the official liquidator. And as per the memo of calculation filed by the official liquidator with waiver, an amount of rupees, how much is outstanding? 10
My
lakh
lord,
2,000.
6,16,661 with
That
the
is
waiver.
with waiver.
With the waiver.
With the waiver, the amount is 6,16,661. And without waiver, the amount is 10,02,881. The respondent has not even appeared before this court, nor he has sought for any waiver from the court. In some of the cases, considering their respective pleas, court has granted waiver when the respondent who has not come up before the court and he is not seeking any waiver. This court is not inclined to grant waiver to the respondent, and accordingly, the application, this is number
This is
234 of
C-
2020
yes, ma'am.
is allowed. Directing the respondent to pay the outstanding amount of 10,02,881. Yes.
Serial number 15.
My lord, this is also an application for recovery of arrears of rent.
I appear for the respondent in this matter. On the last occasion, that is last week, the matter had come up
Yes.
after a long gap.
Yes.
And thereafter, I have been furnished at the instruction of the court a certain statement regarding computations. I'm instructed through a counsel in Delhi, my lords, and I have written to them. And they have reached out to the client, and it is their indication that they need nearly about 4 weeks' time for them to revert with reconciliation. And therefore, I would seek time, my lords, from this honorable court for reconciliation.
When was wakalat filed in this matter?
No, quite some time back, but this pertains to a set of facts, which in my view, my lords, was already resolved as of 2021. And payments were already made to them, because on my perusal and without instructions from the client yet, what I do notice is that there was a reconciliation of accounts between the parties in the year 2021. And pursuant to the reconciliation, they went ahead and issued invoices, and payments have been made, acknowledged as well. But I would now see from the statement that they go back to the year 2016.
No, when is that statement? When is the statement served on you?
Oh, this was about 5 days back.
5 days back.
Yes,
The
this was only
statement
last
as
week.
on date, my lords.
Submitted that the latest memo of calculation is served on the counsel for the respondent, and the land counsel submits that they require 4 weeks' time.
My lords,
to
if I may
this.
just point out, one order of this honorable court dated 19th April 2023. They say they appeared for the reconciliation exercise, but the order records otherwise. If I may just point that out.
19th April 20.
No, my lords, I'm sorry, that may not be correct. I'm sorry, that's a different matter.
The requires a 4 weeks' time to come up with their memo of calculation and to respond to the same. This is matter on 20th of March. Yes, please.
16. The liquidator for
My lord, this is also a matter for recovery of arrears of rent.
Serial number 16, my lord.
Yes.
Yes, my lord. My lord, in that the calculations that was given, my lord, without waiver, it was reflected as 12,29,000, and along with the waiver, it is 8,05,314. There is a small variation in calculation, my lord. One payment that is made, I am informed that one payment that is made is not reflected in this. Let the matter may be taken up next week, my lord. According to me, the calculation would come up somewhere around 6 lakhs. If the amount is 6 lakhs, and if I'm able to confirm the same, I think in a span of 30 days or 45 days,
My
I'll be
lords,
able to
then he
clear
may
that.
remit the admitted 6 lakhs, and the balance amount we can of course reconcile and do the
Yes.
needful.
45 days, my lord. I'll have that remitted.
30 days, my lords.
The
We have already cleared the entire thing.
this court on.
And my lord, there is one submission, my lord. In that amount also, they are supposed to raise 2 invoices, my lord. unless the invoices are raised,
My lords,
but
this
I will
we've
anyway
clarified.
remit
The
the amount,
reason
but
is
it's a
that
request, my lord, that let them raise for,
No. You admit that 6 lakhs amount is a due.
yes, my lord, yes, I admit that.
That
I-
amount you pay, whatever that has to follow, then they'll come up with a clarification. Whatever is
Yes.
required, you can also ask, then it is subject to
We'll do that.
further orders. So I'll record that from today,
We'll do that.
within 45 days. 45 days from today, you'll be paying the amount
Yes, my lord.
of an
It
amount
may
of
be
rupees
recorded.
6 lakhs. Yes.
Yes. 6 lakhs, my lord. Matter may be listed after 45
Yes.
days, my lord. That way
Yes.
I'll have it
Very
complied.
And in
as
the meantime,
Yes.
then you also serve him, what is that?
we've served, my lords. He just has to get back to us on what is the difference that he believes has.
He says he has already sent you back the reply
My lords, we have.
about some, some of the payments which is made is
Lord,
not
we
Two
finalized.
invoices.
Yes, Lord.
I'm told that the OL has not received any response to that effect.
Yes, Mr. Counsel, OL has not received the response.
No, my lord, mail has been sent very well indicating
Ma'am, now
that
Again, send the mail, they'll
issue
respond
must
in
not
the
been
meantime.
raised by them.
My lords, the
Yes,
amount
yes,
due
yes.
now, as
Indeed,
per
indeed.
us, if we grant waiver, those should not be granted because they are defaulting tenants. It's 6,53,000 as of today.
So, the difference is 53,000.
53,000 if waiver is granted. my lord.
Yes, so that again has to be, it's subject to the further orders of the court.
Yes, ma'am.
As per the official liquidator placed before this court, the calculation memo, as per that, without waiver, the outstanding amount is rupees 12,29,000, and with the waiver, it is 6,58,000.
No, my lords. With now, since that payment is reflecting in our system, without waiver, it is 10,77,000.
Without waiver, 10 lakh,
77,649 rupees.
yes,
And with waiver, 6,53,609 rupees.
6 lakh, so it is, like counsel appearing for the respondent submits that, as per their calculation, they have to pay only an amount of rupees 6 lakhs. And 6 lakhs and.
No, 6 lakhs, 21,534.
21,500, and about the remaining amount, he has already sent his calculation to the OL by way of email. OL submits that they have not received such.
No, my lords, we've received it. I'm sorry.
Still there is a difference.
There is still a difference
They have
even after
received, they have
reconciliation.
received the email, still there is a difference, and they'll reply to the email and email about the difference in amount and what is the calculation of the OL. Then the OL also submits that whether the petitioner is entitled for the waiver or not has to be decided by this court. As the waiver that is granted earlier is altogether on a different basis, and to the tenants who were regular in paying the amounts and who has the difficulties, who has faced difficulties in COVID period. According to the official liquidator, this respondent is not entitled for any waiver. Next part. Whether the respondent is entitled for waiver or not will be decided by the court in due course. Now, if it is calculated that he is entitled for the waiver, the respondent submits that admittedly, he is admitting an amount of rupees 6 lakhs
1,534.
or 521, so and so. That admitted amount he shall pay within a period of 45 days, within 45 days from today. And in the meantime, the OL shall send the response to the petitioner and to the respondent, and the respondent shall also respond on that. And on the next date of hearing, basing on the material placed before this court, the appropriate orders will be passed. List this matter on today's 7th. 7, 15, that's 26. We'll have it on 26th of March.
Grateful.
This is
Indeed.
matter on 26th of
obliged.
March.
For 17,
My lord, this is also a rent recovery application.
Arjun Rao.
For the
Last occasion, your lordships had noted that they had paid us up to the 31st of March 2021, and they vacated the premise sometime in November 2023. So there's a due between those periods. So they took time to furnish details on that.
Have they given you?
Nothing
Lord,
yet.
I'm seeking some more time.
Why?
My Lord, they gave this calculation to me on the 30th of January. Need a little more time.
According to you, what is the amount?
According to me, nothing is due.
Nothing
Nothing at
is
all.
due.
According to me, I've paid everything. My Lord. My Lord, there was another order passed in a related application, related CA, where, my Lord, I was given some breadth of 1 year's time to make all arrears.
No,
due-
according
all
to you,
arrears
there are
good.
no arrears.
According to me, no, nothing at all. According to me, nothing at all.
So
I'll have
anyway,
to
that
place
order, it is, whether it's there or not, because there are no arrears.
No, my Lord. There was an order. I paid in terms of that order, and thereafter, according to me, there are no arrears. The
He's-
calculation,
What are your pay?
after the order, I paid.
He
Now I'll have to
paid
place
in
that
terms of
calculation.
the order up to the 31st of March 2021. These were dues up to that date, which he undertook to pay in 12 equated monthly installments. That I'm not disputing, he's paid. But thereafter, he continued to occupy the premise up to November 2023, for which he still has to pay. I have taken note of every payment that he's made up to date, my lords, and thereafter I furnished this memo of calculation. There is a due. Now that due comes up
At the
to 10
request
lakhs
of land council
24,000.
respondent, finally, list this matter on 5th of March for filing as, for filing his response to the calculation filed, the calculation memo filed by the official liquidator.
Serial number 18,
But may I make one submission? This statement which they've served on me is showing some arrears for the earlier period of 21-22.
Whatever it is, you can respond.
No, because the statement now made at the bar is that the earlier amounts are paid. What remains is only from March of 2023 to November of 2023. That's the statement now made at the bar.
Only on
But-
that, whatever is the
Yes,
statement
but
they
the-
have given.
But the written calculation given to me showing that there is an arrears of a previous period. On that basis, I'm saying that everything is paid. So, my lord, let them make it clear what exactly, which period they are
Yes.
talking about. Let
So
them
my
curve
lord,
it in.
what has happened, sometimes what they'll do is they'll skip 2 payments, my lords. That may be of the old period. That time we had filed application, the hearing was going on. Now those things were not considered in the application. Now, my lord, they'll show the past payment due. We'll keep on adjusting their dues against them.
No, they'll come out, they've come up with their calculation memo. You can respond to that,
I'll
whether it's
respond.
paid, not paid, whether it's right, wrong, according to you, respond to it. Yes,
serial number 18,
Back to appear for the
yes.
respondent number 1. It's last date of hearing, I had given the statement of accounts calculated by us. They have to refer now. No, we have not calculated waiver, please. I have mentioned in the statement. Look at the statement which I have submitted last week. According to the OL Millards, the statement what was given on 31st January, till 31st January, it was up to 1,9,95,103, without considering the waiver. There has been no dues from our end. Up-to-date rents have been paid insofar all the 4 units are concerned. And now,
So
according to
you, no dues.
the first respondent,
No dues,
no
according
dues.
to you.
According to us, no dues. Even during the, let me make my submissions,
Yes.
please. First COVID, 3 months waiver, 100% was not considered. Second waiver, for 50% waiver which has been given, 50% amount has been paid. That has not been calculated in my statement what has been given. According to us, without considering the waiver which has been not considered by the OL, it comes to 17,22,832. If the waiver is considered, then what is due as of today is only 6,10,489 rupees. That is the statement I have given to them.
That's the difference.
That is the difference.
17 crores.
No, not 17 crores. Out of 1 crore, what they make the claim.
No,
What
you
the
said.
due, if
you
the
said
waiver is considered, my lords,
If the waiver is not considered, what is the outstanding amount?
17,22,832.
17 lakhs.
Yes, my lords.
And if the waiver is gonna given,
then the balance would be only 6,10,489.
and according to you, that you paid already.
Yes. No, that is the amount which I have to pay.
So now the
I'm
issue
willing
is
to pay.
whether you, now, what is your outstanding without waiver?
For April to June, 3 months, 100% for 2020. Then my lords, 50% for May and June 2020. Now, how they have calculated waiver, their calculation only shows it, my learned friend will see. They have calculated 100% waiver from April 2020 to June 2020, 50% from July 2020 to December 2020, 100% from January 2021 to March 2020.
How can it
No,
be?
that is not.
How can it
That is
be?
not-
I have,
No, you can calculate the waiver basing on how the court has granted in respect of similarly situated persons. And 50% of the rentals for the period of 1/5/2021 to 36/2020, when there is a lockdown, but the respondent is allowed to operate his business is waived. It is in respect of which the very
no,
same.
not in this case, not in this case. One of the tenants,
During the pendency of the matter, the accounts between the persons have been reconciled, all the due. The 100% rental payable for the period of 1/4/2022 to 7/6, that is 4, 5, 6, 3 months. Where there is a complete lockdown. So what court has granted is 3 months between 1/4 and 7/6. Other is 1/5 to, so that is another 1 month. 1/5 to 36.
no, not in this case, my lords, in the other matter.
This case,
Please, my lords.
in other cases.
Please, my lords.
So the court, I mean, in all other cases also, where they plead that such a situation is also there in there, where court can consider only this 1/4 to 7/6, 1/5 to 36.
If that is
So that
applied to this
calculation-
case also, if the statement is made and
Have
given
you-
to us, then I will,
Made the statement in the same manner, giving the waiver?
no. No, this is, no, this,
Pass
what
on.
the statement, what has been submitted is not
Is this a
considering the waiver.
statement?
No, you have made it.
Is it a statement?
The statement what I have as on 25/1/2025 is the summary of rent amount outstanding without waiver, my lords. Yeah, this is what has been given.
No, there is a column. Rent as per agreement with waiver, rent as per agreement without
No,
waiver.
what has been given to me is not that.
Look at it now. Please look at it.
Can you have that, please? The one what I did.
So 1/4/2020 to 7/6/2020. But you have included,
They have included, my lords. That is what I have been saying.
oh, in the next column, you have shown that deduction. Yes.
This statement I have just received. What I had received,
Please
was
look at it, will pass.
we will.
It's a very simple calculation. You're saying that with waiver, without waiver.
Yes,
What is waiver is given or not given? It's a simple calculation. Look at it, we'll pass orders in that.
my lords, I have already submitted the statement of accounts on the last occasion, last week. If that is to be considered by the
My
OL,
lords, we have considered, my lord, let me make a
That is what
submission.
he's saying. You have calculated the waiver
I have not calculated.
as,
I have not
where
calculated.
is that your calculation? Let me see.
I have submitted in the last day,
Where is that?
last week. Last date of hearing. It is there, my lords.
I'm asking them for it.
You have calculated as 17,22,832.
17,22,832. Yes, my lords.
Balance.
That is the balance without considering the waiver. If the waiver is considered, then what is the liable, what we are liable to pay is
Saying it as,
6,10,489 only.
it is 86,51,962 according to you.
Yes, my lords.
How can there be that difference between two
My lords,
calculations?
my lord.
Let them, my lords.
No,
What
my
happens
lords,
is that
one-
I can also depute one of my account per person. Let them go to their office at their given time,
My lord, just
reconcile,
one
and
submission.
I'll pay the amount. If at all, I'm ready to pay this 6,10,489 immediately.
My lords, one submission.
If
Let
any
them-
difference in amount is there, we will also pay that.
Let them make an affidavit of what waiver they have calculated or not calculated.
We have not calculated.
If they have not, my lord, let them put it in affidavit, I'll prove it, my lords.
That's what, here it is, they have the
My-
statement.
My lords, my Simpson, if we consider, and the sheet is.
No, I'll fix a date, let them come on the day to your office and it is submitted
Please, my
that
lords.
it is according to the respondent tenant, without waiver, they have to pay 17,22,832. And they're entitled for the waiver and it would come to 6 lakhs and odd.
Please, my lord.
According to-
6,10,489.
6,10,489.
89.
And as per the official calculation of the official liquidator, with waiver, after
No, without
granting
waiver.
waiver, it is 86,51,962. And without waiver, it is 1,09,95,103. Land counsel appearing with the respondent submits that. They'll set with the OL and with all the person will set with the OL.
Please.
And they'll sort, they will sort this out. And will sort this, and then they will sort this out on 17th
Any date, my lords?
or on 5th,
All right,
on 5th February,
5th of
February. Oh, no, today is holiday. On 13th February,
all right.
on 13th February,
At their office, my lords.
the respondent shall reach the official liquidator and shall sort out this and shall come up with the latest statement before this court by 6th of March.
Please, my lords.
Yes,
Sale number 19.
Also for recovery of arrears of rent, my lords.
what happened?
Well, so paying for respondent number 1, well, so the last date I had entered appearance.
Hmm.
My client is not in India currently once he's traveling. I'm seeking 2 weeks time, but that's the sole reason my wakalat is still not here also. In 2 weeks time, we'll get back to them, my lords.
When did you file your wakalat? You didn't even file till now.
Well, I just not paid. Only on last date morning, we had received instructions to appear before this court, my lords.
Before somebody else was appearing.
My lords, may I submit? My lord, serial number 19
Uh,
was before owned by someone else. Now it is owned by the person who is on serial number 20,
mm,
3NR,
mm,
as per the terms of agreement which have been served to us. So my lords, in both the cases, different advocates were appearing. These are the same entity case. If they'll disagree, I can.
Who appears in 20?
Shekhar Shetty, Anil Kumar Shetty, for respondent.
Finally, 2 weeks' time is granted for filing their, the memo of calculation. This is matter on 6th of March.
Much observations.
No representation for the respondent. This also on 6th of March, 21.
21.
The last date, lords, submitted, we'll conduct a reconciliation exercise. That was done, my lords. Just filing a memo for this whole court. Madam,
My lord, only difference is waiver.
Waiver.
Waive only 9 lakh.
What is the business?
Sorry, my
What is their business?
Luxury clothing brand. It's a
Ultra
luxury.
clothing brand, my lord. Burberry.
Oh, Burberry.
please, my lords.
That's just the email that we had sent. No. apart.
So now the difference is waiver. If they're entitled for waiver, no amount to be paid.
Please, my lords.
They have paid meanwhile we were discussing,
Madam.
my lords. Partly.
Right?
They just paid meanwhile we were having a discussions. In between they paid something. That's why there is no amount to be paid.
Please,
From on
but
27th or 8th.
please, that was
If
for
the waiver is not granted to them, how much they need to pay?
approximately 9 lakhs, my lords.
No, without the waiver, my lords, it would be 28 lakhs
Lakh 8,000.
approximately. With the waiver, it would be 9,62,000. I'm just
Still some
furnishing
more
a
amount to
copy of
be
the
paid.
memo.
No, I'm sorry.
So just now you're saying that without waiver, no amounts to be paid.
No, my lords. What I was saying is, my lords, what they are saying, a waiver calculation was, total amount to be paid was 28 lakh without waiver. If the waiver is granted, it is 9,62,000. This is what I'm saying. If waiver is granted, 9,62,000.
No, that amount is cleared or not cleared?
No, my lords. This is what is pending now. It was much more before the hearing started.
No,
Now
no,
it
Manoj,
is reduced in the
May I
meantime.
make one submission? The memo that I have filed now was what we, at page 4, my lords.
Hmm.
This is the sheet that we prepared along with the OL's office. And
Hmm.
while we were discussing, my lords, they said the only pending was 9 lakhs. Now, if there's more, I'll have to check because
What is pending is 9 lakhs.
and that, and as far as our submission is, that is the waiver amount, 9 lakhs. Now, if they're saying different, I'll have to check, I'll take instructions on this.
How many
Bec-
times? How many times?
Manoj,
you have
because,
to
Manoj,
check?
we sat with this was on a call with the OL's office that the sheet was prepared.
My lords, may I
At
just
page
point
number
out to
4,
a table that
this
we
was on the,
produced?
Let's look at 4.
My lords, can I just, I've put in both our calculations in my memo. My lords may just have my memo at page 2, table 1. I can just show where the difference arises. My lords has it. I just passed along a copy of the memo.
There. Hmm.
My lords has table number 1.
Hmm.
There's one column which is calculation as per the OL. The other one is as per the tenant.
Hmm.
The rental dues between 2016 April and Jan 2025, that there's no dispute. Both of us agree to the same sum. Now, the COVID waiver is where the difference of 9 odd lakhs arises. We say with COVID waiver, it is approximately about 18.
No, how you arrived at 27 lakhs 73,000?
He arrived at that figure.
That's what I am asking.
Manoj, that is the 50%. So, Manoj,
No, how the waiver has to be calculated?
Please.
It is as per the order passed by the court in a previous,
Please,
in
Manoj,
other matter.
please.
So did you calculate in that manner?
Manoj, as to the best of my knowledge, yes, but allow me to reconfirm with my client. Now, Manoj, may I just point out that the outstanding, now, if I'm not wrong, the outstanding dues as on 4/2 without waiver only be 9,62,000?
No, this is with our waiver, it will be 9,62,000.
After waiver, as per their calculation, it is 9,62,947. Only now the difference is,
Please,
what is, how the waiver is calculated?
please. Manoj, I will just check about this. I'm sure there must be some explanation. I'll come back to this honorable court.
Simple calculation.
Please, I will just check because I won't be able to make the calculation on my own. I will check because as far as I was on this call as well when this sheet was prepared. On this call,
Simple. Where is that order? Give him.
C165.
Everyone has a copy of this order, my lords. In fact,
Yeah, so you know that,
Sorry.
what is how, no, just know in the other matter, they have passed on.
Please allow me to just check and sometime next week I'll come back and submit. I don't think there should be,
For such a small amount, again, you come back in the next.
because
week.
if you're not supposed to pay it, well, I will check. All I'm saying is I will check.
You have your calculation.
Manoj,
Simple mathematical.
I will take it to the
calculation.
client and ask them if they've done it right or not. That's all I need to do. Nothing more than that.
That
Because
you can ask the client,
please,
that you can ask the client right away.
please, I can't do it right when I'm before this honorable court. Manoj.
Right away in the sense, today.
I will check with them today, but give
Will
me,
pass over
no,
tomorrow.
Manoj, give me, next week I'll come back.
Why we unnecessarily agenda matters like this?
Manoj, because I'm sure we can close this out. I'm not saying anything more than that. Only reason why
No,
I would
simple.
put it to tomorrow.
You say that you are entitled for waiver.
Please,
For
Manoj.
waiver, there are certain months.
That's right.
3 months and another 1 month. So 4 months waiver here. What is the rent? If you deduct that 4 months, what would be the amount?
That's right. So let me just check with them because I don't want to do that instructions, Manoj.
No, you're happily enjoying this.
Manoj, we're not defaulting on anything else. It can't be that the impression can't be that we're enjoying this because we're continuing to pay rents and whatever is due.
You should pay what you're supposed to pay.
Manoj, and
There
I'm
is
saying that's
the parties
absolutely
who
right.
spend
We are
both the
supposed to pay.
As well as the respondent has placed a calculation before this court. The difference between both the calculation is about an amount of rupees 9 lakh.
62,000.
62,000. The waiver, this difference is coming in the waiver that is calculated between both the petitioner, the OL and the respondent and the respondent. Then counsel the first respondent submits that on this, he'll come up with instructions.
Please.
This is matter on 12th of February.
I'm grateful.
In a lighter way, my lord, I think their per day sales will be higher than the difference amount. It is such a ultra high luxury brand.
I'm grateful, Manoj. Obliged.
Yes.
22.
My lord, I appear for the official liquidator. This is, my lord, an application under 446, my lord, where the company in liquidation is owed certain money from third parties for goods or services supplied, my lord.
The principal amount is so and so, now along with interest it is calculated. Yesterday, the
lord.
other day you were
On the
saying
last-
some
on the-
admitted amounts, what is that?
Please, my lord, on the last date, I sought for time seeking that I'll file objections and communicate to my client. I've communicated. What has happened is the directors are all in different parts of the world. So they have to meet and subsequently call for a board meeting and decide on this. So that I'll need 2 weeks time. What I've been instructed is seek for 2 weeks time so that they can.
When did you receive notice in this application?
Last year, my lord.
Huh?
I received it
Last year, then?
Lord,
Court
yes.
will not wait till all your
I do
directors
understand.
meet at one place.
I do
And they have no alternative but to meet and.
But I have no
file
legs
the-
to seek for time on that ground, my lord. But what I've been instructed, I'm informing.
This court has granted time to the respondent.
May I make one submission, my lord? Nowadays, when we are doing through VC, my lord, I'm sure board meetings can be conducted through
That's
VC.
what.
And they have in the
31/20/25, this court has passed an order.
please, my lord, the 8
The
lakhs
counsel for the
admitting which
respondent
they're
shall
not.
argue the case or else appropriate orders will be passed. Again today, the counsel appearing with the respondent stating that the directors are in, they are in different countries. As said, they couldn't conduct the meeting and he couldn't, come up with specific instructions in this request side. Finally, list this matter on 27th of February. No further time will be granted and appropriate orders will be passed. That-
May I
Sincere
make a
apologies.
request? May I make a request for the undisputed amounts to be paid, my
See,
lord, the interest, but
That's where it is. He is not on the last occasion also. He says, I cannot say that.
please, my lord.
Serial number
Grateful.
23.
Please,
Liquidated.
my lord, this is an application for recovery of dues. This is
The
based on,
cause for the respondent lists this matter on what happened.
My lord, in this respect, we are disputing the amount, my lord.
What are you admitting then?
My lord,
There must be something admitting because you're a tenant.
my lord, there is also another dimension, my lord. The notices they have consistently sent, relying on the fact that we owe them rent. If we look into the rental agreement which we have filed along with the objections, my lord, our tenure expired in March 2017. And we have filed the exhaustive annexures along with our objections. We owe them no rent. In addition, my lord, I have furnished them security deposit in 2008 and 2013. During
So
the
you vacated the premises in 2017.
March 2017, my lord.
Hmm.
But I am craving a 2 weeks accommodation because I want to file a reconciliation statement, month-wise rent, which we have completely paid them. And we have been
The
disputing
respondent
it.
wants to file the statement of the, what is it called?
Monthly reconciliation of rent, my lord.
Monthly reconciliation of the rent. The list is matter. After on 19th of March.
Please.
Yes.
Obliged.
Number 2. Serial number 1.
Any password matters in the company matters?
my lords, serial number 4 was passed over to 230 for their
And
instructions.
then the other one,
The
what is the other matter?
number 3.
That my lords, the
Party.
Party in person. Yes.
It's number 2. Part at serial number 1. Rajan 15. Petitioner.
We stand for petitioner, Your Honor.
Case Nagareddy for
We had filed a
respondent.
suit for permanent injunction and we had filed an amendment application, Your Honor.
Yesterday also they were not there.
No, Your Honor,
Yesterday there was not, the respondent was not there.
not there, Your Honor.
Please give it. Give all the matters. All the 3 are connected. What is this case? Nagareddy, NOC? I think he has given up wakalat. What is that in the cause list?
Case Nagareddy in the first matter.
Hmm.
The second matter is not.
In all that, the commissioner, no? This NR Grisha is a standing counsel.
So many applicants are on the back.
Hmm.
On previous occasions, for those who applicants who appear, their name is reflected.
What is it? No, noted. On last occasion, somebody appeared.
Here in that.
What is his name?
NR Girisha, Your Honor, for second matter he had appeared, ma'am.
In In 1 and 1.2, registry is directed to print the name of Mr. N.R. Girisha. Though he appeared on the last occasion, on one occasion, on the last occasion and today, there is no representation on behalf of the commissioner. Print the name of additional advocate general, somebody. Additional advocate general, print the name of additional advocate general. This is smarter tomorrow. Commissioner, somebody has to represent.
May I pray for Monday, Your Honor? May I pray it for Monday?
If it is not tomorrow, then a long day. Yes. Yes.
Serial number 2. Srinivasan T for petitioner, MP Chandra.
Petitioner, my lord. Defendant's writ petition. Being agreed by the order of the Loc Adalat.
Loc Adalat.
Because this Loc Adalat was held during COVID period, where the presence of the parties was not required, but the counsels could have compromised the matter. And this defendant was not present. She had not instructed for even compromise of the matter. My lord.
Let's see the order.
Order is at page number 18. Page 18.
And what is the remedy of the party?
Remedy of the party, there is a compromise in respect of the property belonging to this defendant.
No
appeal.
If you are questioning a compromise decree that is passed, what is the remedy available to the party?
Remedy available is only to file a writ petition to set aside the order. And no appeal as such, as against the order of the Loc Adalat can be.
Petition under 227.
Please, my lord.
Writ petition under 227.
226 and 227.
Not under 227. I think it is only 226.
226.
And then why is it under 227?
226, there is a mention that the writ petition is under 226 and 227. 226 and 227.
No, completely those two are different.
226, I'll restrict my writ petition only to 226.
220?
6.
If it is 226, it wouldn't come here.
Actually, my lords may kindly appreciate.
Please understand, if you restrict it to 226, 226 writ petition is not before this court. It is only 227 writ petitions are listed before this court. So, if you say you restrict it to 226, it has to go before the appropriate court. And 227, you cannot maintain a writ petition.
Actually, this is the order of the Loc Adalat.
That's what I'm saying. No, it is like this. Loc Adalat, writ petition, and as per the law, no, any compromise decree that is passed before the very same court, it has to be. If it's a Loc Adalat, then now a 226 writ petition. But not, this writ petition is not maintainable under 227.
220, that is, I have maintained this writ petition under 226 and 227. I'll restrict.
That's what I'll say, listed before the court under 226.
Please.
What do you say?
It is maintainable.
It is maintainable 227.
227.
How?
The judgment of the Supreme Court.
Take that.
The settlement was not accorded by the court. It was referred to the mediation. Conciliator has passed the order. On that ground, writ is the only remedy, not the appeal.
In the rules in Andhra and Telangana, if any of the legal services authority,
Please.
if these kind have to be questioned, it would necessarily go to before the division bench in a writ petition.
Certainly, if it is recorded by the court.
Not by the court. I'm saying legal services, Loc Adalat.
Please.
Any Loc Adalat award to be questioned, it would place before the division bench in a writ petition of 226.
Please. Here it is not there. paragraph 27.
Yes. Read para 26. You have that? You have the copy
Please.
of it? Let us read para 26.
26. This is what they lodge.
That's what,
Please.
basing on this order is passed.
Oh.
Please read.
This is what their lordship has held in para 12.
Mm.
It is true where an award is made by Loc Adalat in terms of settlement arrived between the parties, which is duly signed by the parties annexed to the award Loc Adalat. It becomes a final and binding of the parties to the settlement and becomes executable as if it is a decree of the civil court, and no appeal lies against to it. Any court, if any party wants to challenge such an award based on a settlement, it can be done only by filing a writ petition, Article 226 and 227 of the Constitution of India, that too on the very limited ground. But where no compromise settlement is signed by the parties, and the order of the Loc Adalat does not refer to any settlement, but directs the respondent to either make out payment if it agrees the order or approach of the High Court for disposal of an appeal on merits. If it does not agree, it is not an award of the Loc Adalat. The question of challenging such an award, a petition Article 227 does not arise. As already noticed that in such a situation, the High Court ought to have heard and disposed of the appeal on merits. Next paragraph, 27.
No, it is like this.
It is.
Basing on this judgment, the court said it is that it applies in our considered opinion. That's the law.
Please.
In that law, what they say, what is the distinction between 227 and 226?
Make no difference.
No, but that's what it's made. If you read it,
Please.
That's what it reads.
Confined to 227 again.
226.
Yes.
It confined it to 226.
Please.
Not 227.
But either to in our courts, any interrogatory order by the trial court, 227.
No, that is, but not in a case of compromise.
Please.
It has to go before, it is under 226, not under 227.
Please.
Writ court is not under arising out of this kind of, it's more or less a revision petition, either you name it a writ petition or
Registry will raise an objection.
no,
Then
but
you are simply
you
referring
know,
to.
if you look at it, the apex court has relied on a judgment of a earlier bench and passed an order.
Please.
Earlier bench makes it very clear in that order that under 227 it cannot be. And when it comes to the order, it says 226/227. Because there is a lot of difference
Please.
exercising jurisdiction under 226 and 227. Please come. Delete from the caption. Parter. On 4/2/2025. Then counsel for the petition is present and there is no representation on behalf of the respondent, and this matter was directed to be listed and a parter today. Today when the matter came up, then counsel appearing for the petitioner submits that that the present writ petition is filed aggrieved by an order passed by the Loc Adalat,
E-Loc Adalat,
Loc Adalat, dated
19/9/2020.
19/9/2020, whereby the plaintiff and the defendants are permitted to compromise in terms of the compromise petition. And it is also observed that the compromise shall not come in the way of any third party claims or acquisitions, boundary dispute, if any. And directed to draw the decree in terms of the joint compromise petition. It is the grievance of the petitioner that
He was not a party to the compromise and
she never signed the compromise, the joint memo.
joint memo, joint affidavit, as well
It
as.
bears the signature. They are denying the signature.
Though she was never a party, the signature that appears on the joint memo does not
Joint
belong to
affidavit.
the petitioner.
And compromise petition, all the three.
The signature on all the relevant documents does not belong to the petitioner,
Except for the wakalat.
except the wakalat.
Wakalat.
And on that,
Wakalat, okay, even
on
wakalat
that-
also.
I know, I'm not dealing with
Please.
it. And except that, and as such, they've come before this court filing a writ petition under 227, under Article 227 of the Constitution of India. Then counsel submits that in the grounds he has stated about 226. Then you have struck off 226. It is stated that the petition is filed under 226 and 227. And a writ petition is maintainable before this court. The learned counsel for the respondent also submits that in the light of the law laid down by the apex court in Bhargavi Constructions and another versus Kotta Kapu, Mutyam Reddy and others, reported in 2017 Supreme SC 4428. This court has the jurisdiction under Article 226/227. This court has perused the order of the Honorable Apex Court, where the Honorable Apex Court had referred to the judgment of the in case of state of Punjab, referred to a three-judge bench of the apex court. In case of state of Punjab, it is that where do you get that citation? Parties?
Paragraph number 26 does not refers to the citation.
No, that is on 25. And the only state of Punjab, the other party's name is, that is with regard to AR 2008 SC 1209 is the judgment.
Please.
Just look at the citation from the AR 2008 SC 1209, wherein at paragraph number 12, the apex court has observed extract para number 26. Then at para numbers 27, the Honorable Apex Court has observed that in the considered view, the aforesaid law laid down by the court is binding on all the courts in the country by virtue of the mandate of Article 141 of the Constitution of India. The court, in no uncertain terms, has laid down the challenge to the award of Loc Adalat can be done only by filing a writ petition under Article 227 under Article 227 of the Constitution of India in the High Court, and that too on a very limited grounds. This court has perused para number 26, where the apex court, a three-judgment of the apex court in state of Punjab, referred to Supra, had laid down the law. Hmm? Hmm. The award of the Loc Adalat, the award of the Loc Adalat can be questioned by the petitioner by filing a petition under Article 226 of the Constitution of India, but not under Article 227. In that view of the matter, the petitioner is at liberty to convert this petition into Article 226. Accordingly, this person, permission is granted. Yes.
May be permitted to convert it to.
Convert it. Yes,
Sale number 23.
Petitioner.
yes.
Seems to be new surprise to me because the learned counsel who was appearing for the respondent
Please
intimated
allow
that she-
me to engage a new advocate. Just give me one short date, ma'am, please. It's a request.
My lords, may I
Why the
please-
court has no other work but to deal with only your case? I'll pass orders on the merits of it. How many times the court will spend time?
my lords, in
The
fact,
other day
Sorry
you
for the
appeared in
inter-
the chambers
It is-
along with the advocate and suddenly now the matter is for final disposal. You want to engage another
my
advocate.
lords, in
Just
fact,
one date, ma'am. Just one date.
Tomorrow.
I'm really sorry.
my only submission, my lords, to put a quietus to the entire dispute. I've convinced my client. She claims 8.5 extra is what she requires. He's willing to come up till 5. We can still close it because even
That?
she claims that he had borrowed a hand loan from someone. I told my client, just get done with this or else it will not end here. He says that he is willing to pay another additional 5 lakhs, apart from 50 lakhs and apart from the 10 lakhs lease amount, what she wants, he's willing to come for another 5 lakhs. Manoj, I don't think there can be a better offer than this, Manoj. I'm still trying to push him to 8.5 what she claims.
8.5 lakh he has taken 2018, ma'am.
No,
No, no.
I heard everything yesterday.
Plus.
Now tomorrow
act-
we'll list
I'll
this
push,
matter
Manoj,
tomorrow.
I'll push him to
No.
8.5. I've told him, think that you've lost your money in share market or probably you've given it for
But,
charity.
We
No,
will
that
have
is how
it.
it should be, my
no,
lords,
Mr.
because what,
Gautam,
this
we'll
is
have it
extortion.
tomorrow. We'll have it tomorrow.
Grateful.
If she wants, if she do not want any settlement.
It's her
we'll
lookout,
pass
my
on.
lords. That's
She
it.
will only
Yes.
pass.
Grateful.
She'll let her enjoy the consequences of it. Yes, next.
For orders. sale
Tomorrow,
number-
we'll this matter tomorrow.
Grateful, my
It is submitted that the respondent wants to engage another counsel.
Let her not take an adjournment tomorrow again, my lords,
It
please.
will not be, no adjournment will be granted.
Grateful, my lords.
Yes.
Obliged.
Sale number 4.
Petitioner in this case, my lord.
Yes.
Yes, Nagaraja for petitioner.
Alar's application ಹಾಕಿದಿರಿ ಸ್ವಾಮಿ.
Rectification raised on IA 1/25 to 3/25.
Alar's application ಹಾಕಿದಿರಿ ಸ್ವಾಮಿ.
What he says?
Cost title, that is delay days not mentioned and full cost title not.
ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ.
Do it, comply with the objections.
ಮಂಡೆ
2 weeks, 2 days time is granted. By weeks time is granted for complying with the office objections. Yes, next.
Sale number 5. Anantram GR for petitioner.
Yes.
Sai Reddy, respondent.
I have filed a memo with respect to.
Give that memo.
Though, my lord, I have filed a memo for dispensing with the notice to the proposed legal representative, that is the widow of deceased respondent number 5. The Lord, I am the defendant number 2 in the trial court. Plaintiffs who are the respondents 1 to 4 before this honorable court in their petition. They don't take steps with respect to respondent number 5, who is dead as on 18/8/2020. and on the trial side.
That is because, my lord,
No, kindly,
proceedings have been
I
stayed
think
by,
he should kindly bear with me. for a moment.
just court, my lord, wanted to
I asked
clarify.
it, that's
Please,
his
much
response.
Because proceedings have been stayed by this court. When I intend to file an application, they say I cannot take any application because there is a stay in the writ proceedings. Therefore, the court has been recording, await further orders, await further orders.
It is submitted that the fifth plain, what is that? Fifth?
Fifth respondent, who is defendant number 1 in the trial.
Defendant number 1 is no more until no steps are not taken, and the petitioner has filed a memo seeking dispensation of notice. Dispensation of notice to the proposed LRs of the deceased respondent. Number
Just
5.
3 times I have
As
taken.
no
notice.
steps are not taken in the original suit itself. Learned counsel appearing for the respondent submits that in view of the stay orders granted by this court, he could not take further steps. He could not take the steps to bring the LRs on record. Considering the same, the respondent is at liberty to file an appropriate application before the trial court. And the trial court shall consider the same as far as the application is concerned.
With respect to that,
Defendant number 1.
please.
Yes. Then after that, you can file a, then will
Then
not
truly,
consider
Can
this
you,
memo.
let's make kindly defer it so that let him,
Yes.
otherwise
Yes.
proceedings will be again,
Not one submission.
it will be a catch-22 situation otherwise.
Not one submission I would like to make, my lord. The point, my lord, that has been, that consider, that you
What is the
requested.
interim, what is the impugned order?
I
Court
submit
fee,
it.
regarding court fee,
Please.
my lord, an application has been
Yes.
filed.
May I submit? What? Admittedly, even prior to the date of institution of the suit, I had got this land converted for non-agricultural residential purpose. Plaintiffs misrepresent to the court, file a valuation slip as though it's an agricultural land. The learned trial judge gives a finding. No, it is at your instance you have got it converted, not the plaintiffs. It is for them. That is the finding recorded. Hence, it cannot be treated. We'll have to go by the plaintiff governments. No, that is not the law. Law on the point is once the land gets converted, it is with respect to the nature of the land, irrespective of who gets the conversion done. That is the last settled on.
When was the conversion?
No, conversion, kindly annexure G, I have placed it on record.
Was it
On
year?
12/8/1999.
12/8/1999. When is the suit?
Suit is filed, the date is 30th of 8/99. After the conversion.
What is the suit for?
Suit for declaration of title and for declaring that the power of attorney executed in favor of the deceased respondent number 5, who is the first defendant, as force and null and void, and they don't seek any relief challenging the alienations made in my favor through their agent. Suit of 1999. And which I point out also in my,
No, in this
that is for
case-
them.
No, in this case,
Please.
how this defendant number 1 is, as far as the court fee is concerned.
Court,
what
not defendant number 1. Defendant number 2 has a right to bring it to the notice of the court because I am the beneficiary. I have bought this
The
land.
one who died,
Truly,
whom you are
that he may not have.
referring,
Please.
he is not a necessary
He may not be
party
with
to this
respect to court.
petition itself.
Truly, with respect to court fee,
It is only the plaintiff,
truly, my lord, it is between me and the plaintiff.
between you and the plaintiff.
Truly,
So no other persons are required.
no, truly not required.
You can file an application, your memo saying that they are not necessary parties.
No, so far as this writ petition for the limited question,
Necessary.
please, that I shall
Unnecessary,
file.
why should we go into all that?
Please.
At an earlier point of time, this honorable court, my lord, recorded the submission of the learned counsel stating that you would file a memo for dispensation of notice.
I have filed
That-
this memo, please, now, I have
Yes,
placed
sir.
it on record.
Not required, that is.
Please.
Please, sir.
Unnecessary, no, a party
Because-
who is not a necessary, there is a question of all these LRs,
That
notice.
is the
dispensation.
submission that I
I'll
made.
place
Regarding
that
my
memo
submission,
itself
my lord, this
also.
court said, why do you want to stay the proceedings? The matter is very old.
No, please tell the court. Now as on the day when the suit is filed, it is a non-agriculture land.
Please.
At whose instance it is done, we don't have to go into that. So basing on the nature of the land and as per the value that is reflected in the sub-registrar's office, you will be paying the court fees.
Please.
So what is your submission on that?
My submission is, my lord, there are 2 submissions that I make. Not the trial court has not said at whose, instance the land is converted. Court only says, matter, my lord, is of the year 1999. Evidence issues have been framed. Evidence has already been recorded. On 3 different occasions, PW1 has been discharged because they do not come forward to cross-examine. Now, after filing a 4th application for recalling, now, in order to protract the proceedings, they had filed an application. My lord, stating that one of the documents is not properly stamped.
That application was rejected. They come up before this honorable court challenging that particular order. This court rejects the said writ petition. They go up to the Supreme Court, again gets the SLP gets dismissed. And thereafter evidence is recorded. Thereafter, this particular application has been filed. Court says evidence is already recorded. This can be taken up along with the other issues. At the end of the day, when the suit is either decreed or dismissed.
That is before this court.
That is before this.
Court has not negatived that their contention.
Court has observed that it can be taken up along with the issues, and if at all court fee is required to be paid, court has always have the power to direct the plaintiff to pay court fee before passing the decree. And relying on the this court.
If my learned has completed it, I'll make.
This court has taken the full bench judgment of this honorable court, my lord, has taken a view that
This is the
only
writ petition of 2017.
17, suit of the year 1999. They do not want to cross-examine PW1. They keep on saying that, my lord, that PW1 is discharged 3 times. This court, my lord, has taken a view that only when the question of jurisdiction arises, it can be taken out of turn. But in case court fee is required to be paid, it is a mixed question of law and fact.
Para number.
Your lordship may kindly refer to internal paragraph number 16.
Yes.
In relation to the question arising for determination in this reference, we may observe in the first place that in a civil suit, the defendant may, of course, pleading his written statement that the subject matter of the suit has been the property valued that or the court fees paid is not sufficient. Apparently, as per the language of subsection 2 and subsection 5 of section 11 of the Act 1958, the question arises on such pleas, objections of defendant are envisaged to be heard and decided before evidence is recorded affecting such defendant on the merits of the claim. If the expressions employed in subsection 2 and 5 of section 11 are to be read on their own and detached from the object and purpose thereof, it may be assumed as if in every case, whenever the defendant raises an objection as regards valuation and or court fees, no discretion is left with the court, and the issue arising on such a plea has to be heard and decided before evidence is recorded on the merits of the claim. The same has been the view taken by the division bench in Veeragowda's case. Thereafter, your lordships may kindly skip the other portions. Your lordships may kindly come down to
Para 23.
paragraph 23. We may at this juncture take note of the procedure envisaged by the Code of Civil Procedure that governs the trial of the suit in the Court of Civil Jurisdiction, Rule 2 of Part 14 CPC as standing earlier, provided that where issues both of law and fact arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on the issues of law only, it would try those issues first and for the purpose may postpone the settlement of issues of fact until the determination of the issues of law. The said provision was amended by way of Amendment Act of 1976, and in its present form provides that even when a case may be disposed of on the preliminary issue, the court would pronounce
I think you can skip all that and come to para number that 32.
In the context of Karnataka Court Fees and Suit Violation Act 1958, on the principles aforesaid and for the purpose for which the provision is enacted, we are clearly of the view that the expression shall, as used in subsections 2 and 5 of section 11 of the Act, is required to be construed as directory in nature and not mandatory. In other words, the determination of questions envisaged under subsection 2.
Please come to the impugned order.
Please, Your lordship, kindly peruse. Impugned order, your lordship would find it annexure F. The typed copy I have placed on record, your lordship would find it, it commences from in page 57. What is said across the bar is wrong. I'll demonstrate to your lordship. The order speaks. I'll take your lordship to paragraph 5. In page 57.
Yes.
Kindly see the paragraph your lordship would find it at the end. Plaintiff has filed the suit for declaration and injunction. As per the schedule furnished by the plaintiff, the suit scheduled property is an agricultural land. Accordingly, he paid court fee under section 24D of the Karnataka Court Fees and Suit Violation Act. It is not the case of the plaintiff that he converted the suit schedule property into non-agricultural purpose. It is the contention of the defendant number 2 that after he purchased the land, he got converted the suit schedule property into non-agricultural purpose. Hence, for the act done by the defendant number 2, plaintiff shall not be made liable to pay court fee. This is what it's wrong. If at all the land has been converted by the plaintiff himself and thereafter the plaintiff sought relief of declaration, then the contention raised by the defendant number 2 could have been considered. For the purpose of the determination of the court fee only, the plaintiff government has to be considered. I strongly will not take an exception to this recording of the finding by the learned trial judge. It is not the, as your lordships.
But the way you were saying altogether a different case.
Yes.
Your lordships may kindly read
No,
the
no,
same.
it has dismissed the application.
Yes.
Not your lordships may kindly see the observation that has been made.
See, how can.
Even if the
application-
defendant, my lord, it is 3/4 of the page, my lord. Even if the defendant number 2 proves the plaintiff has to pay court fee on value of the GP as,
In that case, what should the court do? The court should keep the application pending.
Pending, it should have been deferred.
my lord, your lordship may kindly observe. that
My
this
rights are
particular issue-
curtailed.
This particular issue, my lord, that has been raised shall be considered along with the other, my lord.
Where is that? That should be the observation.
My lord, your lordships may kindly see.
No, that is not what you are saying, what the court said.
My lord, your lordships may kindly see. Last 6 lines of the, about 7 lines, my lord. Value of the G, as the plaintiff has sought for declaration to declare the GPA fraud document, nothing prevented this court to direct the plaintiff to pay court fee even at the later stage.
Hmm.
Hence, I am of the opinion that defendant number 2 has not made
Where
out.
is the issue with regard to the court fees? Then we will direct the court to frame an issue with regard to the, what is the court fees? And
Also take up other issues together, my lord. and
not, it is
that-
not.
that can be
it is
done.
not a
But I'm
particular
not-
Issue.
I'm not, my lord.
Should be, I know one issue shall be framed with regard to what is the correct fees to be paid. And the court shall decide it along with the other.
it
But
is-
in this case, it is not like what you submit. Please come,
Observation is there.
please,
No,
give
please,
the, please give the memo with
please,
regard to.
I shall file it. Right.
Please give it.
I shall file.
The agreed by the orders, we'll ask the court to frame an issue.
Please, madam. Please.
Agreed with the orders passed in I number 20, whereby the court had dismissed the application filed by the defendant number 2. Defendant number 2, or seeking a direction to direct the, to consider the court fee before proceeding with the case. The defendant, there is, the plaintiff has filed a suit for declaration and injunction. According to the plaintiff, the suit scheduled property is an agricultural property, and he had paid a court fee under section 24D of the Karnataka Court Fees and Suit Valuation Act. It is a case of the defendant that even before filing of the suit, the land is converted from agriculture to non-agriculture, and the court fee has to be paid, considering it as a non-agriculture, as a non-agriculture property. It is the court had dismissed this application. While dismissing the application by way of the impugned order, the court observes that it is not the case of the plaintiff that he converted the suit scheduled property into non-agriculture purpose. It is the contention of the defendant number 2 that after he purchased the land, he got converted the suit scheduled property into non-agriculture purpose. Hence, for the act done by the defendant number 1, plaintiff shall not be made liable to pay the court fees. If at all the land has been converted by the plaintiff himself, and thereafter the plaintiff sought the relief of declaration, then the contention raised with the defendant number 2 could have been considered. And for the purpose of the determination of the court fee, the plaintiff government has to be considered. The court has also discussed about how the matter has been dragged on. Further, it is observed that even if the defendant number 2 proves that the plaintiff has to pay the court fee on the valuation of the GPA, as the plaintiff has sought declaration to declare that GPA is fraud document, nothing prevented this court to direct the plaintiff to pay the court fee even at the later stage. Hence, the court, and hence there are no grounds to entertain the IA and accordingly dismissed. Learned counsel appearing for the petitioner, defendant number 2 submits that such a finding by the court is perverse. It is submitted that the court fee has to be paid as per the nature of the land as of the date of filing of the suit, and but not basing on who has converted it whether it is the plaintiff or the defendant, he submits that the findings of the court are contrary to law and contrary to the facts. Next para. Learned counsel appearing for the respondent plaintiff submits that in the light of the settled law, the issue that what is the court fee has to be paid, the court can always deal with the same along with the other issues, unless it's an issue with regard to the jurisdiction of the court. It is submitted that he had relied on a full bench judgment of this court in case of Venkatesh R. Desai, represented by his power of attorney holder Arun R. Desai versus Pushpa Housemani and others, reported in Laws, Karnataka, 2018, 10-111. Where relying on this judgment, then counsel submits that the court can as well decide the issue at a later point of time. And only to drag on the proceedings, these applications are filed by this application is filed by the defendant number 2, and court had rightly dismissed the application. Next para. Then counsel, having heard the counsels on either side, peruse the material on record. The suit is for declaration and injunction. An issue is the IA is filed stating that when the property is a non-agriculture property, the court fee is filed is paid, considering that as an agriculture property. If the court feels that such an issue can be decided along with the other issues that are framed in the suit, the court ought to have deferred the same, and the court ought to have made an issue in this regard whether the court fee paid by the plaintiff is proper or not. But in this case, the observations in the impugned order, the observations that are made by the court and the manner in which the IA is dealt with, and the impugned order cannot be sustained. Cannot be sustained if it is for the court to see that the proper court fees is paid. When the material on record discloses what is the nature of the property, the court has to accordingly hear the parties, look at the evidence, and pass an appropriate order. But in this manner, in this scripted manner, court cannot dismiss the application. In the considered opinion of this court, the impugned order needs to be set aside. Accordingly, this court is passing the following order. The order impugned, dated so-and-so, passed by so-and-so, is set aside. Number 2, the trial court shall frame an issue with regard to the court fees and shall decide the same along with the other issues. Next, it's a docket order. A memo is filed stating that the court fees, the order that is passed, the aggrieved party is the plaintiff. As such, the notice to other respondents is not necessary. Accordingly, notice to the other respondents is dispensed with.
In fact, my memo, which I have placed on record for your lordship's consideration, covers this aspect, which your lordship just read few minutes back before I commenced my submissions, wherein it's been recorded on.
It's more on about dispensing notice to them.
To the proposed LR, because he is now dead. Hence,
instead of that,
I'm placing it in any event. I'm placing.
Please give that.
Please, madam.
Yes.
Matter is of the year 1999.
The matter is of the year the suit is of the year 1999. The court shall expeditiously dispose of the petition, the suit itself, but not within a period of 1 year from the date of receipt of the copy of that.
He may have to again take steps again. That if your lordship just
But that order will go.
Please.
That order will go.
Maybe, but he's sick. Lord, I need to, as an officer of the court, I need to bring your lordship's notice. Kindly peruse the prayer that he has made in the plain days for declaration that a particular document executed in.
That is for him now.
Truly.
If he takes steps, court will decide. If he doesn't,
since your lordship
that
got to fix up
earlier
the
that
time again,
petition to be filed and all, that all you remove. All are closed, whatever it is.
Since he is dead, Lord, the time frame fixing again, steps and all that again.
If he is not able to take steps, court will not hear it.
Please,
What the court can do.
That can be done, my lord. We'll take out and summons and see it is served. If not,
Yes, next 6.
Till number 6. Authorized the.
Yes.
Await TCR.
Please.
TCR is awaited. This is matter of 6th of March. You see. Kept in the file. Paso.
Malad, next week, Malad.
Next.
I have to
this
seek
is
some.
matter on 5th of March. Yes, 7th.
7.
On submission, Malad, interim order kindly be extended.
ತುಂಬಾ long date ಆಗುತ್ತೆ.
This is matter on 10th of 13th of February. Yes.
Malad,
7.
interim order may kindly be extended.
Interim order earlier granted is extended. Yes.
Cell number 7. Mahesh S for petitioner. Rectification of office objections on a yes.
The office objection shall be rectified within a period of 1 week, or else the application shall stand dismissed.
Cell number
For
8.
further reference to the court.
Kindly pass on.
Pass over.
Cell number 9.
Praise time, my lords. Petitioner is out of station, minutes.
Huh?
Kindly praise time.
My lord, I oppose that the
Let's
prayer
see
of the
how
other
many
side.
times this request
The,
is-
my lord, the earlier advocate obtained an order of stay to the executing court, cases, execution
What
case.
happens?
It is for recovery of the amount, my lord.
Before me, it comes
Yes.
up on 31/20/25.
It is of 2020, my lord.
And no,
Order is passed in
forget
2020.
about the other.
Filed NOC wakalat, my
Then
lords.
27/1,
Thereafter also, there are 10 to 15 dates of hearings
But
have
NOC
I-
come before this on, my lord.
yesterday, I think I made it very clear, whatever it is, 31/20/25, you have to argue, or else orders will be passed. You can't, your client, whenever he wants, he can't give a,
No, my
take no objection from the other
But
advocate.
the,
And again, the ball won't start, rolling from that day.
yes, miss, but we have got.
It is not the ground for adjournment, my lords.
Kindly, my
Tomorrow,
lords.
finally, no, please don't ask. Tomorrow, at the request of land council petitioner, no further time will be granted.
Cell
Next
number
10.
10. Cell number 10. H.N. Basavaraj for petitioner. Shivanand Meki for
And
servant.
respondent counsel.
Petitioner, my lord, my senior sir is held up in court hall number 7. Please pass over.
Not pass or kindly have done.
At the request of land council, the respondent list this matter on 25th of February. Please. 11th.
Cell number 11.
So petitioner, my lords.
Sanand.
There's some kind of medical emergency, my lords, my seniors. You could attend the proceedings for them. The matter can be
Going for
posted for
response.
next week, my lords.
That's on March 7th, at the request of land council. Court by order dated 23/4/2024 has already dismissed a petition against learned person. Who's this lady? Why? So what about the remaining respondents? It is, that's why they're arguing. It's final hearing. Hmm. Hmm.
Now they are posting the applications, sir.
This is under final hearing. Matter is coming up for final hearing. Huh? Let it be there. Let it be there. Yes. How many of the matters passed over? What, how many matters are coming? No, if that's the case, all these 3 matters are also tomorrow. Because when again for 2, 3 matters, I can do some work. Tell the advocates. keep it off, all the 3 on the requirement, if not tomorrow, then some other.
Serial number 11, date and ಕೊಟ್ರಾಮ. The date 11.
Madam, ಎಲ್ಲಾನು ಮುಗೀತಾ?
Nagashiri, I am here.
So matters now mostly my extra photo. Serial number 11, date and ಕೊಟ್ರಾಮ. Date and
Madam, court officer.
Nagashri, wait. Madam, serial number 3 pass over ಆಗಿತ್ತು ಬೆಳಗ್ಗೆ. Serial number 3 pass over ಆಗಿತ್ತು.
ಅದೇ ಇದೆ, ಅದೆಲ್ಲ ನಾಳೆಗೆ ಅಂತ ಹೇಳಿದ್ರು.
ನಾಳೆಗೆ. Nagashri, ನಾಳೆಗೆ.
Okay, okay.
Serial number 3, which is passed over, madam directed to list the matter tomorrow.
Okay, madam. Thank you.
Thank you.
Actually, ma'am.
ಅದನ್ನು if any urgent.